All right, at this time, Chair will lay out HB 1529. Who's that? Representative Campos.
It's me again. Good afternoon, Vice Chair Lujan and committee members. Thank you for the opportunity to lay out House Bill 15.
Excuse me 1 minute. The chair offers up a committee substitute to HB 1529. And go ahead.
Okay. Thank you for the opportunity to lay out House Bill 1529 relating to the duties of court-appointed guardian ad litems, attorneys ad litems, and attorneys in certain suit-affecting parent-child relationships. Last session, HB 135 was passed, which requires DFPS investigators to verbally in writing notify an alleged perpetrator their right to audio or video record interviews, and before the interview is conducted, be notified in writing of their right to request an administrative review, which they must sign in acknowledgement. Currently, there is no court requirement to ensure the 2021 enrolled law is being followed. HB 1529 provides a subsection in Chapter 261 of the Texas Family Code to include the court's responsibility. In order for more direct supervision of DFPS investigative work, the court must review and definitely conclude the department followed the laws established last session. Additionally, the bill allows better data to be collected for the department's administrative review investigative findings report, because more families will be aware of their right to request this review. The court, before the adversary hearing, will be required to confirm in writing and in open court an alleged perpetrator was notified of their right to audio or video recording any interview with DFPS and their right to an administrative review. If the court finds the alleged perpetrator was not fully informed of their codified rights, the court may not consider the evidence gathered from the alleged perpetrator in the investigation or interview. An example of the evidence gathered includes a drug specimen collected at the residence of the alleged perpetrator, which in common practices in DFPS investigations. A committee substitute will update the language to ensure only the ill-gotten information gathered from the alleged person or persons will not be used in the adversary hearing. The substitute ensures witness or professional interviews and evidence can still be presented. I'm here for questions, and I reserve the right to close.
Thank you. Members, any questions? No? Okay. At this time, the chair calls up Cindy Dyer. Give us your full name, who you represent, if you're on for or against the bill.
Good afternoon. My name is Cindy Dyer, and I'm an attorney with Texas Rio Grande Legal Aid. I manage the Family Defense Project. My testimony was invited, and in my capacity here as a legal aid attorney, I registered as neutral, as I thought that did indicate the resource witness that we had talked about me testifying as, so apologies if I selected the wrong button. For context, my project at Legal Aid, we represent indigent parents at all stages of CPS intervention with a focus on early defense, meaning we are some of the few attorneys who are out in the field with our clients during an active investigation. We are one of only 3 projects or programs in Texas to offer this service, and there are very few attorneys and very little oversight in the investigative field. While we and our clients do appreciate the actual written notifications being provided during the investigative stage, as this was implemented in the 2021 session, not everyone receives those. There are 2 requirements from the last session. The requirement to be notified in writing that the parent has, or the alleged perpetrator has the right to record that initial interview, and also the right to an administrative review. However, there's no current enforcement or relief mechanisms available in existing law for when our clients do not receive those notifications during the investigation. The current only option available to parents or alleged perpetrators who have not received those required written notifications from 2021 session is to make a complaint to the Office of Consumer Affairs, which typically just results in a letter to the parent that there was a policy violation, but there's no impact on the parent's case even if there was no notification provided. So this bill since there is no oversight during the investigative stage, either judicial or otherwise. This bill actually allows relief for a parent to seek if they're not provided with the required notices. If the department is already following the 2021 laws and providing those 2 notices during the investigation, then there should be zero issue for the department to say so and attest to that in court at their adversary hearing, which is all this bill provides. Per this bill and the committee's sub, the only time evidence under this bill is excluded is when the department doesn't follow the existing law that has been in place for over 2 years. I'm simplifying this due to time limitations, but any lawyer can tell you that if a party doesn't follow the rules in obtaining or disclosing evidence in regular litigation, there are various provisions in the rules of civil procedure and rule of evidence to exclude that evidence. So adding in additional protections for families to the investigation stage, as continues to happen in every legislative session, is helpful to all Texan families. But it's bills such as 1529 that actually allows something to happen when a state agency itself doesn't follow the law. Thank you.
Thank you so much. I know we have a question. Representative Wu?
Yeah, thank you, Vice Chair. And we've had this discussion on another bill that I'm not going to bring up right now, that we've heard in this committee already. And I think the comparison that we always make is like this is comparable to Miranda, right?
Sure.
And when you violate Miranda warnings, there is a clear consequence, fruit of the poisonous tree, and evidence is knocked out. So, but my kind of like the conundrum that I've been like rolling around in my head in dealing with all these bills is like Miranda applies at arrest, right? And that's a very clear black and white demarcation. When you're arrested is very clear in the law. My concern on this type of situation is, when does your right to be informed of your rights get invoked, right? Because if you, like a lot of times at the beginning of the investigation, CPS just is talking to people, and they may suspect that one person is the perpetrator. And so my example would be like, let's say auntie calls in a child abuse report, and she says, oh, it's the dad, right? And they go talk to auntie first, get the information. They don't warn her. They don't provide any warnings. And then they go talk to dad. They do provide him with warnings and everything else because they think he's the suspect or he's the perpetrator. But dad provides a lot of evidence saying, hey, no, this is like the 4th or 5th time auntie's done this. It's a vendetta. She's the one who actually is causing the abuse, right?
Sure.
And they go and say, you're right. There is evidence that auntie is the perpetrator, but they didn't warn her when they first talked to her because, right, she wasn't a suspect, wasn't a possible perpetrator. So my question is then, does everything that they collected from her, from auntie, that is very self-incriminating, is that now knocked out because they didn't warn her because auntie wasn't ever considered at the beginning?
And I think my struggle with that fact scenario is that if the aunt didn't have conservatorship rights, then the adversary hearing doesn't involve her, right? So if she is the perpetrator...
Well, we don't know.
Right.
We don't know. Auntie might have the kids. Auntie might not have the kids.
Sure. And, I mean, the rules are already in place that the notifications have to be provided.
No, and that's a frustration. I get it.
Yeah. And so our issue is there's no teeth to anything, right? So we can tell people all day, sure, did you get that warning? No. Well, what am I going to do about it now? They already have all the information, and now we're barreling towards court. If not this, then what, with no judicial or other oversight? And I think that providing everyone those rights that is being talked to by the department isn't hurtful. It is already a pre-printed form that can be distributed, telling everyone they have the right when they meet CPS, just like they have the right when they talk to law enforcement to have an attorney present or to record the interview. I'm not sure of the downside of that.
Fair. Thank you.
Sure.
Members, any other questions? Thank you very much.
Thank you.
This time the chair calls Carrie Wilcoxon. If you can let us know your full name, who you represent, and if you're on for or against.
Good afternoon, Vice Chair Lujan and other distinguished committee members. My name is Carrie Wilcoxon, and I am testifying in support of 1529. I helped draft this.
Representing yourself?
I'm representing myself, sir, yes. I helped draft this piece of legislation. I will be testifying from perspectives of a former investigator and a business owner that now provides CPS case consultation services to attorneys and parents throughout Texas. I think that the witness before me laid out some really great, that's exactly what I would have said, right? Like, this is a checks and balance. And it was born out of a meeting with a legislative representative here and with some attorneys. And the question in the meeting was, how do we force CPS to follow law? We have all these wonderful laws and policies around these child abuse investigations, but how do we enforce them to follow them? And so that's where this comes from. The idea would be that, of course, if we provide 307 rights up front and we ensure that those were provided, the consequence being at an adversarial hearing that if they weren't provided, that ill-gotten information and evidence cannot be used specific to the alleged person. But I appreciate your question, and I'm not an attorney, Representative Wu. I'm just somebody that kind of comes in here and does this stuff and from the perspective of a former investigator and been consulting on these cases. But I would imagine in a criminal investigation, if a detective's talking to a neighbor who's just a witness at that point, and then later on in their investigation, they discovered that individual may be a suspect, then when that suspect becomes a suspect related to that crime, that's when they're provided their Miranda. And so just like, I don't know. No, okay. Well, in CPS cases, if they're talking to grandmother, if she's not a suspect at the beginning of the investigation, during that investigation, if she does become an alleged perpetrator, she is then titled inside the state system as an alleged perpetrator. And at that point, 307 should be read to her. Those rights should be provided to her.
Well,
And I think what the previous witness said, and in her answer, and I don't necessarily disagree with it, is just that CPS would need to, in order to deal with the fact that there is no Miranda-like clear nexus where there's a very clear cutoff point of, hey, you're under arrest, therefore you get Mirandized. Because we don't have that in a CPS case, that just go ahead and just warn everybody. Anybody that you talk to, no matter who they are, if they're not an employee of the state, if they're not an employee of the government, you hand them a piece of paper that says here are your rights, and we don't know if you're a suspect or you're a possible perpetrator or not. Here are your rights, and you're talking to us voluntarily, and anything you say can and be used against you. So, I mean, that's a fair way to do it.
When I wrote this, and the intent of it was to protect those that were subject of a CPS investigation that would then expose their parental rights to termination.
No, but I think my point was that during investigations, I've seen this in cases before, is that you don't always know who the target is until later on, until everything's been fleshed out, right? And then that's when we end up having. My concern is that somebody gets away with something because they weren't the first person to be talked to, or they weren't suspected at first.
Okay.
Is that fair?
Yes, I understand. I would only submit that this is a starting point for checks and balances. We don't have anything like this just yet, and it would at least start us moving in the right direction. Yeah,
and like I said, I'm appreciative of this, and I totally understand the need to put teeth into legislation, because I'm all about the or what part of legislation.
Okay. Thank you very much, committee members.
Any other questions, members? Nothing? Thank you so much.
Thank you.
Appreciate it. At this time, the chair will call up Jeffrey Morgan.
Thank you. My name is Jeffrey Morgan. I'm testifying on myself in support of this bill. There's really not much for me to add, so I'll keep this really short. I just want to thank Representative Campos and the other lady who was working on this. We have to protect our families from the tactics that CPS has used. Probably the most complaints that I get have been from people that have been abused by CPS, and it seems like there's no recourse. These protections are absolutely necessary. Thank you.
Thank you. Any question, members? All right. This time the chair will call Taryn Champagne.
Good afternoon. My name is Terrence Champagne, and I'm representing myself, and I'm in favor of this bill. I think everybody else has pretty much said what I was going to say, so big thumbs up on this bill, and I hope it passes.
Thank you so much. Appreciate it. Any questions? All right. The chair calls up Carlos Damon. Full name, who you represent, on, for, against.
Oh, thank you, Mr. Blanco.
Okay.
Carlos Flores, I represent myself.
Okay.
I'm
On, for, against?
in favor.
Okay.
Pretty much, again, with the other two gentlemen in front of me.
Okay.
So very simple. Looks good.
Thank you. Any questions? All right. Chair calls up Julia Hatcher. Full name, who you represent, on, for, against.
Yes, my name's Julia Hatcher. I'm an attorney in Galveston. I'm also the president of the Texas Association of Family Defense Attorneys, which is a statewide organization of attorneys representing parents and children in CPS cases. And we're strongly in support of this bill.
Says you represent yourself also, correct?
And myself, yes. And what we found is that not only is CPS not giving parents their right to record the interview, but they're telling them specifically, you cannot record the interview. So even though it's been the law for 2 years, they're not following it, whether that's a lack of training, whether that's incompetence, whether that's obtuseness, I don't know. We don't know, but that's what's happening. So we agree with the prior testimony that there needs to be some teeth to the law, because you can put into law anything you want, but if there's no way to make them follow it, it's not really a whole lot of good. As to your suggestion, Representative Wu, I agree with you wholeheartedly. Let's give everybody their rights. And then they don't give the witnesses all the information that give them their rights. They can't use their testimony either. I mean, they can't use their statements either. So let's just tell everybody, and they don't want to follow the law and do what they're supposed to do, then they're not going to have any evidence at a hearing. I think that's a brilliant idea. Thank you for bringing it up.
Thank you, ma'am. Members, any questions? All right, thank you so much.
Thank you.
This time the chair calls Jeremiah Michael. Mr. Jeremiah Michael. Once, twice, 3 times, okay. He's was testifying in favor. Okay, at this time the chair calls Paula Lajacos. Really? I'm proud of myself. Give us your full name and who you represent, on, for, or against.
I am here representing myself. My name is Paula Vlahakos, and I am testifying in support of. First, let me thank you for allowing me to address you today in support of what I think is a vital piece of legislation. I've been a practicing family law attorney for over 20 years, and from 2015 to 2018, I served as the associate judge in the 247th District Court in Harris County. And in that capacity, I was the judge that presided over our CPS docket. In that capacity, obviously, my job is to protect due process, right, when you're at the courthouse at a minimum. But most CPS cases, many CPS cases, don't end up in court. And although not every CPS referral results in a ultimate court action, every single CPS referral and investigation invokes an alleged perpetrator's constitutional rights at that moment. Maybe not at the referral, that's a good point, Mr. Wu, but certainly before an investigation begins, before they get spoken to, their constitutional rights are invoked and all the due process protections that go along with it. The Fifth Circuit has clearly stated that Fourth Amendment protections extend to social service workers' investigations. So, and the reason is because at that moment, your fundamental constitutional right to stay together as a family and to raise your family without the interference of the state or there's wording in a case, the coercive interference or the coercive power of the state. And those words I chose carefully because although CPS, it's negative, coercive is negative, right? Implies intent. Not necessarily. But I think what we can all probably agree on is that what a CPS investigation is confusing. Who are the perpetrators? When do they become? When are we a social service agency providing help? And when does that turn to then we're also a prosecuting agency and we're also an investigative agency? By its very nature, it's confusing. But as part of that investigation, whether it ultimately gets to court or not, it involves processes that are incredibly invasive. Psychological evaluations, drug tests, counseling, invasive activities that afford incredible amounts of private information to the government. And just like in a criminal investigation where the players are all clear and the roles are clear, the same protections need to be afforded to, the legislation says alleged perpetrators, but I agree, probably everybody we're talking to, because they can become an alleged perpetrator. It can become, we're here to help, and then suddenly or not suddenly become, now we're going to court to ultimately take your parental rights away, which is the death penalty in civil law. This bill addresses this gap in due process protection because I think it mandates that at the outset of the investigation, before you talk to anybody, you need to give them these warnings. And I believe 307 is also being amended to say not as soon as possible, which is what the language currently reads, but at the outset or something similar so that it's immediate. This bill puts the responsibility on the agency, which it already has at some point in the process, to inform the alleged perpetrator of various things set forth in the code, which previous people have said they're not doing or don't do consistently. This puts the onus on them to do it. The timing is critical. The specifics are well set out already. But most importantly, it imposes consequences. And it requires the court to determine that if notice was not given at the outset, and it gives them the ability to exclude that evidence. The necessity of this bill, I don't think, can be overstated. I'm not sure without this type of warning to everybody or just the alleged perpetrator that due process has been afforded at all.
Thank you very much. Members, any questions? No? Thank you very much. Do we have another one? Okay, at this time, the chair will call. We already did. Roland Ortiz. Roland Ortiz twice. Roland Ortiz, okay. He is not here. We have him 4. Chair calls Anton Golakov. Anton twice, Anton 3 times, not here, okay. We are showing him 4. Chair calls Brandon Johnson. Full name, who are you representing, on for or against?
Brandon Johnson, represent myself. I would like to change on the bill to for the bill.
Okay, change you for the bill. Okay. You give us permission to change it?
Yes, sir.
Okay.
Yes, please change it.
Okay, you are now shown for the bill. Go ahead.
All right, thank you. I've been an advocate since 2017. I've been a court watcher, especially online, since COVID. And so I see quite a bit of the one of the things that I see, having said that, is this bill protects the due process. And being able to do the audio and audio video in all proceedings with a timestamp would be preferable. Anytime you have these industry experts, be it judges, guardian litems, CPS, anybody, there needs to be recordings. And so one of the things that I think, though, comes up, and I'll just say this, many times the government actors, including judges, court personnel, and other industry insiders who become involved in the case conspire to create a narrative and predetermined outcome. And that's kind of what, in this CPS situation, that's where it starts. And then they have so much discretion. They got so much leeway. I've been investigated a couple times and talked to a lawyer. They said, well, you either deal with the retaliation or you just do the interview. Now, it all went away. It was just a one-time interview and dismissed. But I have been through that, and it's a very concerning process. One of the things that I think we could add to this bill, because you get into rules of evidence with somebody just turning on their iPhone, and I'm not sure that would be admissible. So you could hire a notary public who would be a third party that would do the video recording and be able to attest and verify that they did it. It would be time-stamped and whatnot. And then that way, even if it's not prosecuted under this code or this, section, at least you could move forward and maybe have a recourse under something else. And I understand Mr. Wu's concern, with these people, if maybe they were a witness to something that transpired or, have a concern for the kid and they don't want to be retaliated against by this alleged perpetrator. And that makes sense. Anybody could, sympathize, empathize with that. But where's the balance? And it's one thing if it's a one time and everybody was fair and open and honest. But if this becomes habitual, is there, somebody had mentioned an internal file within the CPS to where you can see a history of what's taking place. Or maybe it's a group of people that are doing this, and it's a form of harassment. Because we see this a whole lot in these family law cases where false allegations, usually disguised as some kind of domestic violence, child abuse, that's nature. Now you're getting the whole power of the state behind you, and there's nothing verified. There's nobody even to go against. You're just going up and against the allegation and losing your kids. And it's just not right. So thank you for Ms. Campos for proposing this bill. At least it's a step in the right direction and gets the conversation going.
Thank you, Mr. Johnson. Any questions, members? All right, thank you. This time the chair will call Cecilia Wood. Ms. Wood, if you can give us your full name, who you're representing, on, for, or against.
Sure. My name is Cecilia Wood. I'm a board-certified attorney in Austin, Texas, and I'm here today representing the Family Freedom Project, which is a project of the Texas Homeschool Coalition, which does many cases and is highly involved in protecting parental rights, specifically in this, or a large part in the area of child protection services, as well as myself, having practiced in this area. And I think that this is an excellent bill. The committee sub what I think the committee sub is going to say is that it will begin before interviewing. These rights will be told to the party or an alleged perpetrator prior to interviewing. But Representative Wu, I just really understand your concerns because at a minimum, every parent or a person with a court-ordered possession should understand these rights. But as you know, the Gates case said that a social worker has the same duties as they are as a civil servant. And so many of these cases, maybe Auntie doesn't have rights, but she may actually be a perpetrator, and now she's facing a criminal conviction. And I do hope that, as the previous speaker talked about, that they will also hand out these 307 brochures in the beginning so that people know, hey, I'm going to call my attorney, and then call back. So I think this is great, and I certainly hope you pass it out of committee.
Ms. Wood, thank you for your testimony. Members, any questions? Thank you very much. Appreciate it. It's time the chair will call Jeremy Newman. Mr. Newman, if you can give us your full name, who you're representing, if you're on for or against.
Members, I appreciate the time. My name is Jeremy Newman. I'm the VP of Policy for the Family Freedom Project, and we're a statewide organization that works on parental rights issues. A lot of that is litigation related to parental rights, and a lot of that is CPS cases. So I kind of look at this.
And you're for
the bill. Yes, I'm sorry. And I kind of look at this from a little bit of a big picture policy perspective, that very, very frequently this type of situation we discover is that all over the state we're involved in these CPS cases, and the policy of CPS often is actually good. And the difficulty we have is in getting it to actually happen that way. And we'll often end up in communications with the commissioner or people who are in supervisor roles at DFPS who understand what the policy is supposed to be, but there's just this huge difficulty in getting it to filter down all the way to the caseworker level, such that when they're actually talking to the parent at the door, that it's followed correctly. So the thing about this is that it kind of allows you to bypass some of the bureaucratic difficulty in some ways by putting in some accountability that requires that they actually have to follow certain policies and inform people of certain rights at the door. And there's a consequence that comes in that you can hold somebody accountable to if that doesn't happen. And I think that Representative Wu, to the point you made earlier, that the easiest, simplest way to think about this is that it's basically akin to what we do in the criminal process. And, in the criminal process, even if you're not talking about a death penalty case, then you would still have these types of rights. But in the CPS process, they call it the death penalty of civil law because it's so severe. And a lot of people would prefer to go to jail or even be on death row rather than lose their children. And so it just makes sense to include that same level of protection for those types of families.
Thank you. Members, any questions?
Thank you.
Thank you very much. I think that's all our witnesses. Is there anyone else who wishes to testify on, for, or against HB 1529? If not, the chair recognizes Representative Campos to close on HB 1529.
Again, thank you for allowing me to present this bill, and I think it just goes back to accountability and transparency that is much needed with DFPS. And again, with all the cases that I've dealt with in the interim, there was just too many families that didn't know their rights and then winded up in court. And so when you get a knock at the door from CPS, it's terrifying. So we just got to make sure that they're following the process, and they haven't been. And so that's the purpose of this bill. And so thank you, and I close.
Thank you, Representative Campos. The committee substitute is withdrawn, and if there's no objection, HB 1529 will be left pending.